2-1-3-0-0-3 FC, People, the State of Michigan versus Deion, Hanna. This case is set for trial in about 2 weeks. The court has been advised that the defendant wishes to enter a plea. Is that correct, Mr. Fabian?
Yes, Your Honor.
Is that correct, Mr. Hanna?
That is correct.
All right, Mr. Hanna, would you raise your right hand, please? Do you solemnly swear, oath, or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? And Mr. Stay, would you put the agreement on the record, please?
Defendant will enter a no contest plea to counts 1 through 3. People will move to dismiss counts 4 through 7. On the guidelines, people believe on that plea are 171 to 285 months on the minimum. On count 1 and count 2, regardless of the guidelines on the maximum minimum, the people would cap at 25 years. The people would cap the maximum at 60 years. Count 3's minimum not to exceed count 1 or count 2's minimum. All 3 counts to be concurrent. There was a Cobb's hearing set and heard on January 3rd, 2022. And I would request that the court put that statement on the record.
Yes, after having the Cobb's hearing, the court indicated that I would agree to not exceed the advisory guidelines. And Mr. Stay, is that your understanding of the agreement and the Cobb's agreement?
It is, Your Honor.
And Mr. Fabian, is that your understanding of the offer from the prosecution and the Cobb's agreement from the court?
Yes, Your Honor.
Is that your understanding as well, Mr. Hanna?
Yes.
And for the record, the reason for the no contest plea, Mr. Fabian?
Yes, Your Honor. The court has seen the exhibits in the case. There are significant injuries here. I think there is a potential for civil liability. That's the reason for no contest.
Mr. Stan?
People agree.
The court does find that that is a sufficient reason under these facts to authorize a no contest plea. So, Mr. Hanna, the charges that you're going to be entering a no contest plea to read as follows: that on or about March 2nd, 2022, that you were in the city of Fremont, Waco County, state of Michigan, count 1, assault with intent to murder. That you did make an assault upon Jewel Daniels with the intent to commit the crime of murder. This is contrary to MCL 750.83. That is a felony which carries up to life or any number of years. DNA would have been taken upon your arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. You understand count 1 and the maximum penalty?
Yes.
Count 2 is another count of assault with intent to murder. That you did make an assault upon Keegan Ostrander with the intent to commit the crime of murder. This is contrary to MCL 750.83. Again, this is a felony which carries up to life or any number of years. DNA would have been taken upon your arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. You understand count 2, the maximum penalty?
Yes.
Count 3, home invasion, first degree, that you did break and enter or enter without permission a dwelling located at 1045 State Street, apartment 2C, with the intent to commit an assault therein, or while entering, present in, or exiting, did commit an assault and was armed with a knife, a dangerous weapon. This is contrary to MCL 750.110A2. This is a felony which carries up to 20 years in prison and or $5,000 fine plus cost, and a consecutive sentence may be imposed for any other conviction arising out of the same transaction. You understand count 3 and the maximum penalty?
Yes.
Count 4, an armed robbery, which is a life felony or any term of years, is being dismissed. You understand that?
Yes.
Count 5, mayhem, a 10-year felony is being dismissed. You understand that? Count 6, unlawful imprisonment of Jewel Daniels with a weapon, a 15-year felony. That is being dismissed. You understand that?
Yes.
And then finally, count 7, carrying a dangerous weapon with an unlawful intent, a 5-year felony would be dismissed. Is that your understanding of how the charges are being resolved in this case? The plea agreement calls for you to plead no contest to counts 1 through 3. And the prosecutor's agreement for counts 1 and 2 was that you would be sentenced to a term of years not to exceed 25 years on the minimum to a maximum of 60 years. Do you understand what the prosecutor's offer was? And we had an agreement called the Cobb's Agreement where I agreed not to exceed the advisory guidelines. So we would be looking at, I think it was 23 3/4 years on the minimum to a maximum of 60 years for counts 1 and 2. Do you understand that?
Yes.
Counts 1 and 2 would run concurrent or at the same time. You understand that? And count 3, that the maximum penalty on that is only 20 years, but your agreement down there is that any sentence imposed for count 3 would not exceed the minimum sentence imposed for counts 1 and 2. You understand that?
Yes.
Is that your complete understanding of the plea agreement in this case?
Yes.
Have you had sufficient time to consult with Mr. Fabian about your original charges?
I have.
And have you had sufficient time to consult with Mr. Fabian about this plea agreement? And subject to the plea agreement, how do you wish to plead to these 3 charges?
Contest.
You
I'm
understand?
sorry to interrupt, but you did not indicate that count 3 would be concurrent
Oh.
with 2 as well.
Yeah, count 3 would be concurrent with the counts 1 and counts 2.
Thank you.
They're all gonna run at the same time. You understand that? All right. And Mr. Hanna, do you understand with the no contest plea, you're not admitting these charges, but you're no longer denying them?
Yes.
The court has been provided, as part of the Cobb's Agreement, the complete preliminary examination transcript they indicated last hearing that I read. And if I find that the elements of these 3 offenses are contained therein, I would find you guilty. Do you understand that? You would be convicted of these 3 offenses. You understand that?
Yes.
And these 3 offenses would be on your record. You understand that?
Yes.
The only difference in outcome between a no contest plea and a guilty plea is that you don't have to say what you did because you could potentially be sued for personal injuries as a result of what you did. But everything else, the plea agreement still stands. Do you understand that?
I understand.
You also understand that by entering this no contest plea, that you're giving up your right to have a trial of any kind. Further, you understand that you're giving up certain constitutional rights and other rights that you would have if you went to trial. We've listed those rights for you on a written advice right sheet that you signed today. Did you read that document? Did you understand those rights? And have you gone over those rights with your attorney? All right, specifically, do you understand that you're giving up the right to be tried by a jury? That you're giving up the right to be presumed innocent until proved guilty? You're giving up the right to have the prosecutor prove beyond a reasonable doubt that you are guilty? You're giving up the right to have the witnesses against you to appear at the trial? You're giving up the right to question the witnesses that the people would call against you? You're giving up the right to have the court order any witnesses that you would have for your defense to appear at the trial? You're giving up the right to remain silent during the trial?
Yes.
You're giving up the right to not have that silence used against you?
Yes.
You're giving up the right to testify at the trial if you want to testify?
Yes.
Further, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial? Do you understand that any appeal from your conviction and sentence pursuant to this plea will be by application for leave to appeal to the Court of Appeals, and it's not an appeal by right? Has anyone threatened you to get you to make this plea? Has anyone promised you an outcome different than what we've placed on the record today? Are you entering this plea of your own free will? Do you understand that if I accept your no contest pleas, that you're giving up the right to later claim that this plea was not your choice, or that it was the result of any promises, threats, or inducements which are not disclosed to me today? You understand that I'm not bound by this plea agreement, or necessarily that Cobb's agreement that we entered into. But if I don't go along with it, you can withdraw your pleas. You now give up your right to have a trial of any kind, and all the constitutional rights and other rights that you would have as a result of a trial, and do you affirm your no contest? And I guess I would turn to you, Mr. Stay and Mr. Fabian. I'm assuming that you want the court to consider the preliminary examination transcript to determine whether there's a sufficient factual basis.
Yes, Your Honor. People believe it meets the elements of the 3 charged offenses.
Mr. Fabian?
Yes, Your Honor, I believe that has a sufficient record for the court to accept no contest case.
All right. As I indicated, I previously read the preliminary examination transcript pursuant to the Cobb's memorandums that were filed, and I do find that the elements of counts 1, 2, and 3 are contained therein. Are the attorneys aware of any promises, threats, or inducements which have not been stated on the record?
There have been none, Your Honor.
No, Your Honor.
Is the defendant competent to enter this plea?
He is, Your Honor.
Yes, Your Honor.
Has the court complied with MCR 6.302?
You have, Your Honor.
I believe the court has with, I don't know if this is required, but he's not a U.S. citizen. They could have immigration consequences. He is a U.S. citizen, but that I don't think is stated. But otherwise, it has.
I don't usually inquire into that. Mr. Hanna, are you a U.S. citizen?
I am.
All right. All right, the court does accept the plea. I do find it to be knowing, understanding, voluntary, and accurate. I agree to be bound by the terms unless the pre-sentence investigation report reveals something that I'm not aware of. I'm going to refer Mr. Hanna to the probation and parole department for the preparation of a pre-sentence investigation report. The court is going to set sentencing for February 27th at 2:10. And Mr. Stay, I guess I'm anticipating that the victims in this case may want to address the court at the time of sentencing.
That is correct, Your Honor.
All right. So the court will set aside an hour for sentencing. Do you think that would be sufficient?
I believe it will, Your Honor.
All right.
I have had some discussions, so yes.
Okay. All right. So we'll set it at 2:10. We'll block off an hour. If it takes more than that, that's fine, but at least we won't set it for 10 minutes because we pretty much are sure it's going to take longer than that. All right. Anything else for the record before we adjourn, Mr. Stay?
Is there a bond, Your Honor?
There was a $5 million cash assured bond that was.
I would request that the defendant be held without bond and sentence.
Mr. Fabian?
I don't think I have an objection. I believe the statute actually requires it.
So the court will hold Mr. Hanna without bond pending sentencing. And Mr. Fabian, anything for the record before we adjourn?
I think I would just, I don't know if this is the appropriate place to ask, I would request to be part of the pre-sentence interview that is now allowed for this, so to be present in the pre-sentence.
All right. We will notify probation and parole that you wish to attend that interview. Now, with him being incarcerated, I don't know. I think they go over and see him, so, but you certainly have that right, so we'll make those arrangements for you. We'll let Mr. Zira, who does the PSIs, know that you want to be there to coordinate with you.
Thank you, Your Honor.
All right, and if there's nothing else, we'll adjourn for today.
Thank you, Your Honor.